combination of information elicited by the state has created irreparable prejudice which cannot be cured or removed by even a curative instruction by this court, and it arises from a complex implication and the inferences drawn from that. Number one, the state presented properly a jail phone call. The clear meaning and context of that phone call, which was lawfully admitted, I certainly am not disputing that. Nonetheless, the implications of it were that Mr. Morris was either trying to intimidate, influence, or perhaps even threaten improperly this same witness that just testified, Miss Ashley Price. That was put on the record. It is what it is. It is clearly prejudicial, but that is not the basis for my motion.
And before you move on from that, was there any pre-trial motion to exclude any portions of this?
No, sir, and I'm not complaining about it being admitted, sir.
My question is, was there any pre-trial motion to exclude any portion of that telephone conversation?
No, sir.
Yes or no? Okay, move on to your next point.
After that, with this same witness, actually, with the same witness mentioned in the phone conversation, or spoke, Ashley Price, the state, in attempting to rehabilitate or rebut impeachment by the defense that Ms. Price had received some financial benefit from the state in the form of assistance in housing, it elicited from her the reason she needed the help, financial help in housing, saying that she had to move, or eliciting that she had to move due to unspecified threats.
Was that information in the form of a question or a response?
That was a leading question to which she responded in the affirmative.
Okay, go ahead.
Now, Judge, we believe that proper rebuttal to that implication by us that she might have been influenced by any financial assistance would have been to ask her, ma'am, did the fact you received any financial assistance influence your testimony in any way? But that isn't what was asked. What was asked was, why did you have to move? Why did you need the assistance? Was it because of threats to you and your family? Now that put together with the phone call, we think creates a clear implication by the state, by the juxtaposition of those two pieces of evidence, that invites the jury to draw an inference that the defendant was responsible for the threats, not only the implied threats and or intimidation in the phone call, but those threats elicited concerning the financial assistance. We believe those two together in their overall impact have poisoned the well in this case in such a manner that the jury almost certainly has drawn an inference that the threats that were referred to were originated with Mr. Morris, since that fits the clear implications of the prior testimony on the jail phone call. And we believe, Judge, it's a situation where this trial has been contaminated, that it's been prejudiced in a way that simply cannot be cured. So I will make a motion for mistrial at this time based on those grounds.
Mr. Harmon? Mr. Harmon?
Yes, sir. Since I handled the witness, I guess I'll handle the argument, Your Honor. May it please the court. First, I would address counsel's reference to this jail phone call. The jail phone call speaks for itself. It's the inculpatory statements of the defendant trying to influence Ms. Price in so many words, maybe no direct or overt threats, but asking her why she's doing this, or why are you doing that, come see me at the jail, then making statements to his friend and his brother how he needs to talk with her and get with her, and reaching out and going through all these steps to contact her. So in that phone, there is no allegation of any kind of threats outside of that phone call in the state's case before I asked Ms. Price this question today to rebut or to rehabilitate. But I would put on the record that knowing or thinking that that was a possible interpretation, the defense still asked this question about possible financial benefit, even though that was provided to them in discovery and they were told the reason she was relocated was because of threats because of her prior testimony in the Rodney Jones trial. These threats did not occur before that. They started immediately thereafter, and she had moved herself multiple times since then at her own expense and had depleted her resources or her ability to evade what was occurring in the community. She and her sister were being threatened by through the internet and through people coming to their door. Never the defendant, no one related to the defendant. These are people in the community threatening them because they were, quote, snitching, end of quote. That was where the state was going to go with that questioning. But in any event, the defendant's name was never brought up in this question I asked her about being threatened. No fingers were pointed at the defendant, and I don't believe there's any allegation or any inference that can be made against him. It was simply stated, was that because you had been threatened? So I don't believe, Your Honor, that it rises to a due process violation or goes to the heart of the veracity of the state's case or the judicial process or affects it. So I'd respectfully ask the court to deny the motion for mistrial.
Judge, I would just briefly reply that while Mr. Harmon has offered an alternative and harmless explanation of what he was referencing, the jury won't know that. Their natural inclination is going to be to draw the inference that I stated, that is, that the threats emanated from Mr. Morris. And I don't see any way to cure that at this stage. That has already been done. The poisoning of the well has already occurred, and we can't go back and correct it.
I'll make the following observations and findings. First of all, this witness, I think on the record, maybe it first came out across, I don't recall, but anyway, it was before the jury that she testified, and sometime in the past, back in 2010, or sometime thereafter, she received nominal financial assistance, specifically, I think, a couple of months, first and last month's rent. That fact, if you will, was known to the state, known to the defense. I don't think the state brought it out on the record, I don't recall. But be that as it may, it's an impeachable subject. And the defense counsel has the right and the obligation to impeach any witness in any way the defense deems it necessary or appropriate. And that's all right. But you do that, I guess, at your instance or at your peril. Secondly, whenever a witness is impeached, the opposing party certainly has a right to attempt to rehabilitate that witness. And the fact that there's a reason for her having received financial assistance is a legitimate area of inquiry. When Mr. Howard asked the question, I think the question was, it contained the word threats. We had the discussion up at the bench about whether these threats that this witness received were either directly or indirectly from the defendant, Mr. Morris. I made an observation in the ruling, and my understanding of the law is whenever any witness receives threats, it's certainly relevant to suggest that that may be a reason for that witness is testifying in a certain way or doing a certain thing after those threats. But it's certainly inappropriate and wrong for there to be any suggestion that the threat in question came from the defendant unless there's proof of that. And Mr. Harmon candidly admitted there is no reason to think that these threats that this witness testified to were from Mr. Morris directly or indirectly. With respect to, and again, I think cooler heads are here right now, I believe. We had these multiple discussions at the bench, and parenthetically, I think we spent entirely too much time with this witness over not important issues, but be that as it may. With respect to whether Mr. Harmon can appropriately rehabilitate this witness's impeachment, if you will, I think it's all right to let her explain why she had this financial assistance, but that has to be done in some way, fashion, or form so that it's clear that nothing that she did or didn't do had anything to do with any implied or suggested threat by this defendant. Now, The question is before the jury, something about threats. I called the parties to the bench. I think you objected. We had this discussion. The jury's not heard any of this. So that's where we are right now. With respect to your first issue, that is the jail telephone call, and again, it is what it is. The participants were identified by witnesses, one of whom was testified to as being Mr. Morris. And Mr. Morris is, in fact, heard saying words to the effect that he needs to talk to this lady, Miss Price. That in and of itself, I would suggest, since there was no suggestion that it should be excluded pre-trial, it came into evidence. There's no basis for granting mistrial on that basis. With respect to the question about this threats being on the table right now, I'm open to suggestions, first from the state, for the defense. I think you've already suggested that there is no way to do it. Open to suggestions from the state as to how to deal with this question from this point forward. Understanding that you asked a question, it was objected to, and that's as far as it went. Mr. Harmon.
We have time to consult co-counsel.
Yes, sir.
While he's doing that, may I make an observation?
Let him speak.
All right.
Carlos, are they still out?
Yes,
No.
they're inside.
You're inside.
Yes, sir.
Your Honor.
By the way, before you respond, let me just put this on the record. The court reporter was kind enough to bring up the discussion on the record, and this is the way it read. The question was asked by Mr. Harmon, is that because of threats made to you and your family? There was an objection. I said approach the bench. There was never a response by the witness. Go ahead.
Judge, first of all, the state is amenable to some type of curative instruction if that's what the defense is asking for. I don't know. I haven't heard that motion. It's the state's intent not to bring Ms. Price back in here. I have her available outside, but it's not our intent to bring her back in and question her any further. It's our intent, through the testimony of Detective Masucci and then Detective Durkin, to bring in her prior consistent statement from June 30th of 2010 to rebut the allegation of recent fabrication. This relocation,
Statements of what?
her statements to the City of Tampa Police Department on June 30th, 2010 as to the defendant's statements to her that he committed these murders and how he committed the murders, to rebut the allegation now that this financial inducement, which was recent, was within the last month, Detective Masucci will testify, has influenced her in some form or fashion or influenced her testimony.
Well, that's beyond the scope of what we're here.
It is.
Right now, you're suggesting that we just leave things the way they are.
Yes, sir. Unless the defense wants to ask for a curative instruction, we wouldn't be opposed to that.
Counsel?
Your Honor, just so our record is absolutely clear, this is a death penalty case, and I am very concerned that it be clear. I agree with the court that my preface concerning the jail phone call is not the grounds for my motion for mistrial, except that it created a context which gave a direct implication that would lead the jury to an inference from the second exchange concerning the threats to her family. So that's the only connection, but it is a connection of context. Same witness, juxtaposed to one another within a matter of a very short period of time. We've moved for a mistrial. We stand by those grounds. If the court is going to deny that motion, then I certainly think it's incumbent upon me to ask for a curative instruction. I haven't really devised one at this point. We've discussed that.
Well, as we all know, oftentimes curative instructions are more harmful than helpful.
I know they are, Your Honor, but by the same token, ignoring them is also extremely dangerous.
That's your call. I guess first you need a rule on motion.
I need a ruling, yes, sir.
All right, at this juncture, given what I've read in the record, the question being asked, which I'll state for the record, was an inappropriate question at the time. The more sensible way to have handled it would have been to approach the bench to let us know that you were going to ask that question. But be that as it may, the question was asked, the jury heard it, there was no response. I will, at this juncture, respectfully deny the motion for mistrial. Will proceed. That being the case, what would your request now, if any?
Judge, I think I heard, if I'm not mistaken, the Assistant State Attorney, Mr. Harmon, say they would not oppose a curative instruction. I think it might be one possible solution, without abandoning our motion for mistrial, obviously.
Obviously, no.
It is that the state and the defense could stipulate that the references to the threats to her family were not connected with the defendant. There was no evidence they were connected with the defendant. If we stipulate to a statement of that kind, we have, in effect, provided a curative instruction. I don't know if the state's open to that or not.
Yes, sir.
I can say something like, members of the jury, with respect to the question or suggestion of any threat against Ms. Price, counsel have agreed that any such concern has nothing to do with Mr. Morris.
Or that there is no evidence that it has any connection with him, whatever, however you want to word it, Judge. My client apparently wants to speak to me. May I have just a moment?
Yeah, go ahead, take your time. They're all back in the jury.
Yes, sir. Yes, sir.
And that was on read. It was on read the rest.
Yes, sir.
Did they go downstairs?
Yes, sir.
They went down there comfortable. When they smoked again.
Thank you, Your Honor. I apologize for the delay, but my client had something to say, and it took me a moment to understand what his position was. Judge, I am going to ask that in light of the court's denial of my motion for mistrial, that the court give a brief statement that the parties have stipulated to those statements you've roughly worded already in your pronouncement a few moments ago. If that's agreeable to the state.
Yes.
Well, but the attorneys agree that any reference to any suggested threat to Ms. Price has nothing to do with Mr. Morris.
That's fine. That's fine, Judge.
Okay. That being the case, bring in our jury, please. For the record, I think your issue is reserved and protected.
Thank you, Your Honor. Yes, sir. I appreciate you giving us the opportunity to make that record clear. Scott, who's your next witness?
Dr. Masucci.
Okay.
I'm sorry, you're going to have to stay there. Maybe you can just get it over with. No, seriously, McLeod, we were better when
Well, yeah.
I mean, it was just, and I was only kind of joking that they actually really let you play for $300. It's just a case, yes, to postpone prior.
Ready, Judge? Yes, sir.
All rise. Jury is.
Okay, our jury is back and seated, and defending the counsel, please be seated, everyone. Thank you for your patience. Probably took longer than we anticipated. Before we begin with the next witness, I just want to make a statement to you. With respect to just before we recess, let me just say to the jury that any reference to any suggested threat to Ms. Price, the witness who was testified, the attorneys for the state and the defense agree that this has nothing whatsoever to do with Mr. Morris. So I'll ask that the state please call its next witness.
The state would recall Detective Charles Masucci.
Witness is back on the witness stand, still under oath. Counsel, please proceed.
Thank you, Your Honor. Police Court. Good afternoon, Sergeant.
Good afternoon.
Just a few more questions for you. Was Miss Ashley Price, who just testified here, was she relocated her residence into a separate residence with assistance from the Tampa Police Department?
Yes, sir.
And when did that occur, Sergeant?
Approximately 1 month ago.
And can you tell the jurors how the city of Tampa, the Tampa Police Department assisted her in doing that financially?
We provided funds, not directly to Ms. Price, but to an apartment complex. She was provided with $200 cash for moving, and then she was provided with $1,800 for her deposits and first 2 months' rent.
And the $1,800 for deposits and first month's rent, did that go directly to the apartment complex?
Yes.
And the $200 moving cost, did that go to her or to someone else?
The $200 went directly to her. A $600 money order was given to her aunt, who paid the initial, first, last, and security deposit. The security deposit was paid in $600 prior to Tampa Police having the funds, so we reimbursed that through a money order directly to the aunt. She was provided with $200 cash, and then a $1,200 money order was given directly to the apartment complex.
So $200 to her, $1,200 to the apartment complex, and $600 to her aunt to reimburse her for paying $600 to the apartment complex.
Yes.
And proof of that payment by the aunt was produced
Yes.
and verified by the apartment complex?
Yes.
And you said this happened approximately a month ago?
Yes.
All right. Now, prior to assisting her financially, were there other attempts made by the Tampa Police Department to relocate her?
Yes, I spent probably 3 to 4 months working with local organizations, charitable organizations.
Can we approach the bench?
You were saying you'd worked for several months with charitable organizations,
Yes.
trying to relocate her?
Yes, I was looking at long-term housing that provided child care and other things like employment assistance and things of that nature.
And none of the charitable organizations, none of that worked out?
No, it did not work out.
Now, this financial assistance occurred a month ago. Over 3 years ago, on June 30th of 2010, did Ms. Price give a statement to Detective Durkin?
Yes.
An interview in this case,
Yes, sir.
where she advised Detective Durkin about statements the defendant had made to her?
Yes, that was all done on June 30th, 2010.
The dash cam video, which is States B, from Officer Curtis's car that depicts the murders of the officers, was that dash cam video ever released to the press?
No.
Was it ever released outside of the City of Tampa Police Department other than to the State Attorney's Office?
No.
Have any images from it or still photographs been released to the press?
No.
Even to this day?
Even to this day, there is no images out there in public that have been brought to our attention. I'm very confident answering no. We've been diligent in protecting that evidence.
All right. And sometime in 2011, possibly in the summer of 2011, were members of the press allowed to view the video pursuant to court order?
Yes, that did occur.
But they were not allowed to record it in any form or fashion?
That is correct. There was observation by members of the media. I believe there was note-taking, and there was a report, reports made.
Okay, and that was, well, in any event, no one in that, during that viewing was allowed to record in any way, either audio or video, and that was in 2011.
That is correct.
Okay. I'll tender the witness, Your Honor.
Any questions, counsel?
No questions, Your Honor. Thank you.
May he be released, or do you need to remain available?
I ask that you remain, Your Honor.
In the building?
Yes, sir.
Detective, please wait outside. Call your next
Thank you,
witness,
Judge.
please.
The state will call Detective Kevin Durkin.
Raise your right hand. Do you solemnly swear or affirm the testimony you've given us cause to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Right this way, sir?
Hello, Judge.
Sir, please tell us your full name and then spell both first and last.
My name is Kevin Durkin, Kevin Durkin.
Thank you. Please proceed.
Thank you, Your Honor. How are you employed, sir?
I work for the Tampa International Airport Police Department. I'm assigned as a detective.
All right. Detective Durkin, were you previously employed by the Tampa Police Department?
Yes, sir.
And when did you retire from the Tampa Police Department?
In January of 2011,
And prior to that, how long were you employed by the city of Tampa?
29 years.
And when you retired, what position did you hold with the Tampa Police Department?
I was a detective in the homicide squad.
In June of 2010, were you assigned to the homicide unit as a detective?
Yes, I was.
And overall, how many years did you spend in the homicide division or unit at the Tampa Police Department?
I first went over to the homicide squad in 1985. I was there for 9 years. The second time I went to the homicide squad, I went in May of 1998, and that was another 3 years. And the last assignment to the homicide squad was another 3 years when I retired. So in total, 15 years in the homicide squad.
And in your position at the airport, at the Tampa Airport Police, do you also investigate homicides along with other crimes?
I will investigate any kind of case that comes in, including death cases, yes.
Detective Durkin, on June 30th of 2010, was it brought to your attention that a young lady named Ashley Price had come to the city of Tampa Police Department and was advising that she had information about the murders of Officers Kokab and Curtis?
Yes, sir.
Did you interview her and participate in a recorded interview of her?
Yes, sir, I did.
And in that interview, did Ms. Price tell you that on the day of the murder, shortly after the murder, that she had received a phone call?
Yes, sir.
Did she tell you who that was from?
Yes.
And who was that?
It was from Dontae Morris.
Okay. And did she tell you why he was calling?
Yes, she did.
Go ahead.
She said that he called because he needed a ride.
And did she say whether she assisted him or not?
She did not.
She did not assist him?
That's correct.
Okay. Did she say if Mr. Morris had told her where he was or who he was with when he made the call to her?
He never said, according to Ms. Price.
Did Ms. Price tell you that later that day, around noontime, she also had a phone conversation with Mr. Morris?
Yes, sir.
And in that phone conversation, did she tell you that Mr. Morris asked her in the very beginning of the phone conversation to do something in reference to the television?
Yes.
And what was that?
Your Honor, may we approach?
Yes, sir.
Did Ms. Price tell you that the defendant told her that he did it, or that he was the one who killed the police officers?
Yes, sir.
Did she tell you that he told her where he shot the police officers?
She said that he shot one of them in the head.
Okay. Did she tell you that he told her how many police officers he shot?
Yes, sir.
Did she tell you that he told her that his motive for doing this was because one of them went back to run his name and his patrol car, and he was afraid he had a warrant?
That's correct.
Did she tell you that the defendant told her that he produced the firearm from underneath the seat,
Yes, sir.
and that the police officers were white?
That's correct.
And finally, did she tell you whether the defendant told her where he shot the police officers from, whether it was inside the car or outside the car?
I think it was outside, sir.
Do you recall her saying that he told her he got out of the car and shot the police officers?
Yes.
I have one moment, Judge.
Counsel?
No question, Your Honor.
Will this witness be released, State?
Yes, sir.
Counsel? Yes, sir. Released. You're free to go. Thank you, very much.
Thank you, Judge.
Call your next witness, please.
State of Florida calls Yolanda Soto.
Oh, thank you.
Stand right here, face the clerk, please.
Raise your right hand. Do you solemnly swear or affirm the testimony you give in this cause be the truth, the whole truth, and nothing but the truth, so help you God?
Right this way, man.
Slide it a little closer to the microphone. That's good. Tell us your full name, please, ma'am.
My name is Yolanda Soto. That's YOLANDASOTO.
Thank you. Please proceed.
Good afternoon, Ms. Soto.
Good afternoon.
How are you employed?
I'm a crime laboratory analyst. I'm assigned to the firearms section with the Florida Department of Law Enforcement here in Tampa.
What do your duties include in your present position as a crime laboratory analyst in the firearms section?
It includes microscopically examining fired ammunition components such as fire bullets and cartridge cases to determine whether or not they were fired from the same firearm. Other duties include serial number restorations, distance determination examinations, and function testing on firearms.
How long have you been performing that job within the crime laboratory section of the FDLE?
I've been an analyst for approximately 13 years.
Can you give the court, please, a summary of your training, education, and experience that qualifies you for your present position as a crime laboratory analyst in the firearms section of FDLE Laboratory?
Yes, I received a bachelor's degree in forensic science from the University of Central Florida. I was also a forensic technologist for approximately 1 year with the Florida Department of Law Enforcement in Orlando, and I was also in the firearms section. And I completed a 15-month structured program specifically in firearms identification sponsored by FDLE in Tampa.
Over the course of your 13 years with FDLE, approximately how many forensic examinations of firearms and ballistic components have you conducted, roughly?
It's in the thousands as far as the function testing and microscopic comparisons, tens of thousands.
Do you undergo continuing training and education in the field of firearm identification and analysis?
Yes.
What does that consist of?
It consists of armorers courses. I also attended factory tours years ago, and I belong to the Association of Firearm and Toolmark Examiners, where I attend conferences that are put on by them.
Have you been qualified in the courts in the state of Florida to express an expert opinion in the field of firearms identification, analysis, and ballistics?
Yes.
Approximately how many times, ma'am?
Approximately anywhere from 95 to 100 times.
Your Honor, I would tender Ms. Soto to be qualified to express an opinion in that field of firearms analysis and identification.
Any questions?
Defense has no additional word here, Your Honor.
Please proceed.
Ma'am, in your capacity as a crime laboratory analyst in the FDLE lab, did you become involved in the investigation of the homicides of officers Curtis and Cocab with the Tampa Police Department?
Yes.
And specifically, I want to talk to you about your work in evaluating and analyzing a submission from Tampa Police Department of two separate items, projectiles represented to have been taken from Officer Curtis during autopsy and a projectile represented as having been taken from Officer Cocab during autopsy. But before we get into that, if you can give the jury, please, a summary by way of description of the components that comprise what laymen refer to as a bullet.
It's a live round of ammunition. It's called a cartridge, and it consists of a cartridge case that holds the primer, which is the ignition component of the cartridge. It also holds the propellant or powder and the projectile.
What is, did you refer to the term casing?
Yes.
And is that, well, let me do it this way. In terms of a handgun, describe for the jury the mechanism that causes the bullet to be expelled from the gun. The pulling of the trigger, etc., and the force that drives the bullet through the barrel.
Would you like me to explain the difference between a pistol and a revolver?
You can start with that, but let me be more specific. If you could just give them a general description of the forces that work at propelling the bullet from the gun.
Okay. When a live round or a cartridge is loaded in a firearm, when the trigger is pulled, there is a part called the firing pin that strikes the ignition component of that cartridge that's located at the base of the cartridge. When the cartridge is discharged, rapidly expanding gases are generated, and that pushes or drives the bullet down the barrel of the firearm, out the end of the barrel, and then toward the intended target or object.
Does the barrel of a firearm, whether it be a revolver or a long rifle, leave any marks on the part of the projectile that is expelled from the weapon that enables, under certain circumstances, there to be an identification of that projectile to the weapon?
Yes.
Describe that to the jury for them, if you would.
Well, during the manufacturing process of the inside of the barrel, there are microscopic imperfections and irregularities they're distributed randomly, and these individual or unique characteristics of the firearm will transfer onto the surface of fired ammunition components, such as a fire bullet, as it travels through the firearm.
You alluded to describing a distinction between a revolver and a semi-automatic handgun a few minutes ago.
Yes.
Could you describe to the jury what is meant by those terms and how those two firearms are distinct from one another?
With a semi-automatic pistol, a box-like container or a cartridge magazine is used to load the semi-automatic pistol. Cartridges are inserted into this magazine. The magazine is inserted into the pistol grip of the firearm, and when loaded and fired, the cartridge case is automatically expelled from the firearm. In a revolver, the cartridges or live rounds of ammunition are manually loaded into the chambers of the cylinder, and when discharged, the casings will remain in the chamber of the cylinder.
Let me show you what have been admitted as exhibits G1 and G2. G1 has previously been identified as a projectile recovered from the body of Officer Curtis during autopsy, and G2 has previously been identified for purposes of this court as a projectile recovered from the body of Officer Cocab during autopsy. Have you seen these exhibits before today, ma'am?
Yes, I have.
And were these exhibits submitted to the Florida Department of Law Enforcement by members of the Tampa Police Department of Law Enforcement for, among other things, forensic firearms analysis?
Yes.
Can you describe, let's talk about G1 for a moment, the projectile from Officer Curtis. Well, first, how is it that you recognize each of these exhibits?
I recognize each of the exhibits by the unique FDLE case number, my initials, and the exhibit numbers on the packaging.
FDLE firearms section handles a number of cases every year, is that correct?
That's correct.
And so to keep one case separate and distinct from another, a specific and unique FDLE number is assigned to work performed in relation to all evidence submitted in that case? Is that how you keep track of it, so to speak?
Yes, sir.
Okay. And in your handling of firearms evidence or bullet evidence in this case, to make sure that you can recognize each exhibit that you have analyzed, do you put your initials and the case number on each specific initial so that you can do what you're doing today, testify in court that this is what I worked on?
If the exhibits are large enough, I will put my initials on them. If not, I will either package them up in another container and place my initials on them.
Okay. And with reference to G1 and G2, do you recognize each of these two exhibits as exhibits that you worked on in conjunction with the homicide investigation of Officers Curtis and Cocab by that specific FDLE identification number and your initials?
That's correct.
Okay. So with reference to Exhibit G1, the projectile from Officer Curtis, can you describe for the jury what that is?
G1 is my exhibits 1A through 1-D. And exhibit 1A is one fired bullet jacket. Exhibit 1-B is one fired lead bullet core. And exhibits 1C, D, and I'm sorry, there is a fifth one, 1E. Those are 3 lead fragments.
Were any of those items suitable for your analysis to determine whether there were specific characteristics left on the item for identification purposes?
Yes.
With reference to G2, the projectile that was removed from Officer Cocab during autopsy, describe for the jury what that consists of.
That is one fired bullet. It's a .38 caliber class bullet.
Did you examine each of these exhibits with a view towards determining whether or not they were each fired from the same firearm?
Yes.
Describe the process that you performed or undertook to make that determination.
With using Exhibit 1-A and Exhibit 2, I first examined them for similar class characteristics. The class characteristics of a fired bullet include general features such as the caliber and the rifling characteristics. The class characteristics of these exhibits were found to be the same. They were found to be of .38 caliber class, and they both displayed rifling characteristics of 5 lands and grooves with a right twist. After determining that the class characteristics were similar, I then used a comparison microscope to compare the unique or identifying characteristics in the form of scratches or striations on the bullets or projectiles to determine if they were fired from the same firearm.
This equipment that you used to assist you in your analysis was what type of equipment?
It's a comparison microscope.
And to what degree does that magnify?
Mine is up to 60 times.
You've indicated that they both shared, they were of the same caliber, 38 class, is that correct?
That's correct.
And they had specific similar rifling impressions?
Yes.
And the rifling impression is what again, ma'am?
It's 5 Lancing grooves with a right twist.
Okay. Can you try to explain in layman's terms what 5 Lancing grooves with a right twist mean?
Well, rifling is a process that's done during the manufacturing of the inside of the barrel. It involves forming grooves in a spiral direction, either with a right twist or a left twist. And this is done to impart a spin to the bullet. This spin serves to stabilize the bullet as well as improve its accuracy. And barrels can be manufactured with any number of grooves. So for example, if a barrel is manufactured with 8 grooves with a right twist, then bullets fired from that barrel will have 8 impressions of those grooves with a right twist. These bullets displayed characteristics indicating that they were fired from a barrel with 5 grooves with a right twist.
In addition to general class characteristics, did they share other characteristics?
I'm sorry, what was that?
In addition to general class characteristics, did they share other similar characteristics?
Yes, the .38 caliber class.
Okay. Based upon your analysis, did you arrive at an opinion as to whether or not these projectiles, G1 and G2, removed respectively from the bodies of Officer Curtis and co-cab at the time of their autopsies, were fired from the same firearm or from a different firearm?
After comparing the unique identifying characteristics displayed by both exhibits, I was able to identify them as having been fired from the same firearm.
And have we discussed all of the characteristics that you observed that allowed you to make that analysis?
Yes, the individual or identifying characteristics,
okay.
Correct.
From your experience and training, are you able to determine the types of firearms from which these projectiles could have been fired?
I did enter the caliber and information regarding the rifling characteristics into a database that's used in our section. It's called the General Rifling Characteristics Database, and it was developed by the Federal Bureau of Investigation, or the FBI. The information is entered into the database, and then a list of types of firearms that may have been used to fire these projectiles can be generated.
And what did that list include?
May I refer to my report,
Yes,
please? It included Smith & Wesson, Taurus, Ruger, among others.
And those are, Smith & Wesson, Taurus, and Ruger are manufacturers of weapons, is that correct?
That's correct.
Brand names, so to speak?
Yes, the manufacturers.
Okay. Were you able ever to identify either of those projectiles as having originated from a specific firearm?
No.
From the nature of the evidence that you were provided, are you able to determine through your analysis whether those were fired from a semi-automatic firearm as opposed to a revolver?
It was found to be, or the exhibits were found to be consistent with those that are commonly loaded in cartridges that are designed to be fired in revolvers, but that's based on the cannelure that was present, as well as the number of .38 and .357 caliber revolvers that came up in the list that I generated using the General Rifling Characteristics Database.
And if a firearm that was a revolver was used to shoot these projectiles, that revolver would not have automatically ejected the casing of the bullet. Is that correct?
That's correct.
May I have a moment, Your Honor?
Yes, sir.
You referred to the term cantilever. Can you describe that for us, please?
Did you say cantilever? Cantilever?
That's what I meant to say, but that's not what I said.
Yes, cantilever.
Yes, ask the question I meant to say instead of...
Yes, it's a cantilever is a groove that's found around the cylindrical portion of the bullet, and it can serve a couple of or several purposes. One is to secure the outer portion of the bullet, which is the jacket, to the core, or to secure the bullet in the casing.
Okay, those are commonly seen with cartridges intended to be fired from a revolver.
Based on my experience, I've seen them mostly on bullets that are commonly loaded in cartridges designed to be fired in revolvers, yes.
Nothing further, thank you.
Questions, Counsel?
Yes, Your Honor. Good afternoon, Ms. Soto.
Good afternoon.
I will stay close to the microphone. I know that I'm soft-spoken, so please let me know if you can't hear me.
Thank you.
All right. Okay, you indicated you've taken some armorers courses. Have you taken the Glock armorers course?
I believe I did. It was quite a while ago.
Okay.
Smith & Wesson, maybe, I believe I took a Glock. It was maybe around 2001 or 2002.
All right, and would you describe what's involved in taking these armorers courses?
Just becoming familiar with that specific type of firearm, how it functions, becoming familiar with the parts of the firearms.
Okay. And how many hours are involved in becoming a Glock armorer, for example?
I don't recall. Maybe a few hours, maybe 4 hours,
Perhaps 8?
possibly.
That's about the time frame, right?
Okay.
Okay. And you did some research with the General Rifling Characteristic Database?
Yes.
Regarding these projectiles?
Yes.
Okay. And did you come up with a number of potential firearms
May I
that could
refer
have
to-
fired those projectiles? Yes.
Yes. The total hits that were made was 662.
Okay.
That's including the different models of the same manufacturer.
Very well. And you've referred to 38 class bullets, okay? Could 38 class bullets include 9mm Luger rounds designed for a semi-automatic pistol?
Yes.
Could they include 380 automatic Colt pistol rounds designed for a semi-automatic pistol?
Yes.
Okay. 9mm Makarov?
Yes.
Okay. 9mm Largo?
Yes, they're all 38 class.
38 Super?
9mm, yes.
And on, right? So there are a
Yes.
number of different calibers that could be included in this category.
Yes.
All right. And what is the definition of caliber to the jury?
Caliber is a term that's used to describe the diameter of the base of the bullet. It's also a term that's used to describe the approximate dimensions of the inside of the barrel of a firearm.
Okay. And you indicated that semi-automatic pistols are loaded through a box-type detachable magazine inserted into the pistol grip. Is that correct?
Yes.
All right. And semi-automatic pistols then eject fired cartridge casings?
Yes, they're functioning as designed, yes.
Okay. Do they typically eject them to the right?
I'm sorry.
Do they typically eject the fired casing to the right of the shooter?
Yes, typically.
Okay. And could you give the jury an indication, in your experience, how far they are typically ejected from the right to the right from the pistol?
No, that would depend on what the cartridge case hits, where it lands, if it lands on a hard surface. I have no way of knowing for certain.
Okay.
Depends on the cartridge also, and...
So it would
caliber.
depend, I'm sorry, I didn't mean to interrupt. Go ahead, finish your thought. It would depend on a number of factors, the
Yes.
strength of the ejector spring, for example?
It's possible, yes.
Okay.
But when you mentioned about the casing ejecting to the right, that of course would be with the firearm being held properly, without on its side or pointing in any other direction, but straight.
You indicated these particular projectiles had 5 lands and grooves, is that correct?
Yes.
All right. What is a Smith & Wesson Model 52 pistol, for example?
If it's a pistol, it's a semi-automatic pistol.
Okay. Is that in your list in the General Rifling Characteristics database?
And that was model 50-2?
52.
52.
No, 52, yes.
There are many Smith & Wessons in the list, so it's going to take me a couple of minutes. You did say 52, correct?
I did.
I did not find any Model 52s on the list. But the list is not all inclusive. It's
Okay.
used as an investigative tool.
I understand. So it is not exhaustive, correct?
That's correct.
All right. And you defined for the prosecutor the difference between general and class characteristics, didn't you?
The class characteristics of a fire bullet
Right.
is the caliber as well as the rifling characteristics. The direction of the grooves, the widths of the rifling impressions, as well as the number of impressions.
Okay. And you indicated that in your experience, a projectile with a cannelure, for the court reporter, spelled C-A-N-N-E-L-U-R-E, that is more common with revolvers?
I can't say that it's more common. I said that in my experience, I've seen them mostly on bullets that are commonly loaded in cartridges that are designed to be fired in revolvers, but they have also been, I've also seen them on bullets that are commonly loaded in cartridges that are designed to be fired in pistols as well.
Okay. So the presence or absence of that cannelure, well, we may be getting ahead of ourselves, or I'm getting ahead of myself. A cannelure is defined then as a striation in the projectile?
It's a groove around the cylindrical portion of a bullet,
Okay, for what purpose?
either to secure the jacket, the outer portion of the bullet, to the core, which is the inner portion, or to secure the bullet in the casing.
Okay, to hold it in place?
To hold it, yes.
All right. And in your opinion, the presence or absence of a cantilever does not prove whether that bullet was fired from a revolver or a semi-automatic pistol?
That's true.
Okay. I have nothing further, Your Honor. Thank you.
Will you be ready?
No, sir.
You should be released for subpoena.
Yes, sir.
Counsel.
Judge, excuse me, may I have just a moment?
Judge, if I may follow, just one additional question?
Yes, sir.
All right, you indicated that there are 662 different types of weapons with 5 lands and grooves. Is that correct?
It was there were 600 and, I'm sorry, I don't remember the exact number.
I heard 662.
But many of them, for example, are by Smith & Wesson with different models.
All right. Would it be possible for dozens of those to be semi-automatic pistols?
I'd have to again refer to the list if you'd like.
If you could.
Okay. In my list, there are 22
Okay.
semi-automatic pistols, and they were of 9mm Luger caliber.
Very well. Thank you.
Redirect stick.
No, sir.
You should be released.
Yes, sir.
Yes, Your Honor.
Ma'am, you release your speech. Thank you very much.
Thank you.
State, do you have a brief witness?
Yes, sir.
Brief. Yes?
Yes, sir.
Call your next witness.
Deputy Steve Gray.
Your Honor, may I confer with Assistant State Attorney a moment?
Yes, sir.
Nothing but the truth, so help you God.
I do. Right this way.
Sir, please tell us your full name in this book, your first name and your last name.
Stephen Gray, Gray.
May it please the court.
Tell your first name too, please.
Steven.
Thank you. Please proceed.
Thank you, Your Honor. Sir, how are you employed?
Hillsborough County Sheriff's Office.
And in what capacity?
I'm part of the detention security team, our intel team.
Okay, and what rank do you hold there?
I'm a master deputy.
Deputy Gray, let me ask you some questions. Pursuant to your job there at the Hillsborough County Jail, were you tasked with a request to review visitations for an inmate named Dontae Morris?
Yes, I was.
Okay. And you were viewing visitations that had been recorded?
We would watch them live.
Oh, you watched
as they
them live?
happen.
Okay, all right.
Yes.
So you were watching live visitations?
Yes.
All right. And when you were watching them live, did your view of the visitation, would it be similar to a recorded visitation?
Yes, it'd be similar.
All right. Would you be able to see the person who was being visited, their face?
Yes,
And the persons who were visiting them?
yes,
Person or persons, I guess.
yes.
And can you explain to the jurors how that visitation works in the jail? When someone visits someone in the jail, are they in the same room, different rooms, and how they're seeing each other?
They're separated. Usually obviously the inmates in the facility, the visitors in a separate part of our facility, and they can see each other via monitor.
All right. And you were viewing those live as they happened for Mr. Morris?
Yes,
All right. And did you view more than one of those visitations?
multiple.
Multiple, okay. In watching those visitations, did you become familiar with Mr. Morris's voice?
Absolutely.
Okay. Familiar enough to where you think you would recognize it if you heard it?
Absolutely.
Have you had an opportunity to view a copy of the dash cam video taken from Tampa Police Department Officer David Curtis's car that depicted both the stop, the contact between Officer Curtis with the passenger and the driver of that car, and then a subsequent contact between Officer Curtis with the front seat passenger, and then the shooting deaths of the officers?
Yes, I have.
All right. And were you able to hear, in that video when you've reviewed it, were you able to hear the audio or sound transmissions on that recording between the front seat passenger and Officer Curtis?
Yes, I did.
All right. And in viewing that,
All right.
Objection, may we approach?
What's your legal objection?
Defense would renew previously stated arguments.
Okay, overrule, proceed.
you stated you were able to hear the discussion between the front seat passenger and Officer Curtis in that video.
Yes, sir.
Right. Were you able to recognize the voice of the front seat passenger?
Yes, sir.
The person who you saw in the video shoot the officers?
Yes, sir.
And whose voice was that you heard?
That's the voice I know of inmate Dontae Morris.
Do you see him here in the courtroom?
Yes, I do.
Could you please point him out, describe an article of clothing?
He's wearing a red sweatshirt, white collar.
All right. And are you sure of that identification of his voice?
Yes.
Any doubts in your mind?
110%.
Tender the witness, Your Honor.
Questions, counsel?
Good afternoon, sir.
Good afternoon.
All right. And could you tell us what your job description is at the Sheriff's Department, please?
Safety and security of the facility, intel that we pull out of the jail to help our law enforcement side, safety and security of the inmates, our officers, the facility itself.
All right. And what sort of specialized training does that involve, if any?
I've had many classes on intel, pulling intel, interviews, stuff like that.
Okay. Have you had any specialized training regarding the recognition of someone's voice?
No, sir.
Okay. Have you heard of such training in terms of availability for your continuing education seminars?
No, sir.
Okay. And you already indicated you've undergone no such training yourself, right?
Yes, sir.
Okay. So, your opinion then would be no better, no worse than anyone else's regarding someone's voice?
Yes, you could say that.
Okay. Are there additional questions, Your Honor?
Can you redirect?
Yes, sir. You were asked if your opinion would be no better than anyone else's. Would you agree with me that would be anyone else who's had your exposure to his voice?
Counsel, whether the witness agrees with you or not is not an issue. Ask a question.
Would that include people who have had no contact with Mr. Morris's voice, or someone who's had your experience with his voice?
I think if somebody would have their exposure to his voice like I have over probably 100 plus hours of watching live video, they would become very familiar with somebody's voice.
Thank you, sir.
May this witness be released?
Yes, sir.
Yes, Your Honor.
Sir, you release your speech. There you go. Thank you. Can counsel approach 1 second, please? The witnesses, I'm told the state has a couple of brief witnesses, and we'll finish up around 5 o'clock, so we'll recess till now. Call your next witness, State.
Just we have one moment. State will call Deputy Gallus. Stand right here, face the clerk, please.
Raise your right hand. Do you solemnly swear or affirm the testimony given in this cause be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Right this way.
Sir, please tell us your full name and then spell both your first name and your last name.
Michael Gellis, Michaelgelis.
Thank you. Please proceed.
Thank you, Your Honor. Mr. Gallus, how are you employed, sir?
I'm a detention deputy of the Hillsborough County Sheriff's Office.
Okay. Deputy Gallus, how long have you worked for the Sheriff's Office?
6 years.
And you work in the Hillsborough County Jail?
Yes.
Did you, through your assignment in the Hillsborough County Jail, have contact with an inmate by the name of Dontae Morris?
Yes.
And how frequent, during the period that you had contact with him, how frequently would you have contact with him?
I worked his unit for 8-month period, so half the days of those months.
Okay.
So
So
4
about
months.
about 4 months of days?
Yes.
Okay. And during the day when you worked in the jail, how many times would you go into the area where his cell was?
One of the 3 deputies were required to pass by his cell every 15 minutes.
In that area where he was in?
Yes.
Okay. And were you one of those deputies that would do that?
Yes, sir.
Did you hear him talking to other inmates?
Yes, sir.
And would you speak with him on occasion?
Occasionally, sir.
And over the course of those 8 months, did you become familiar with his voice?
Yes, sir.
Did you become familiar enough with his voice to where you would recognize it if you heard it?
Yes, sir.
Have you seen a copy of the dash cam video, recorded video from Officer David Curtis's patrol car that reflects the deaths of Officers Curtis and Kocat?
Yes, sir.
Have you seen and heard the interaction between Officer Curtis and the front seat passenger, both at the initiation of the traffic stop from the driver's side, where Officer Curtis is on the driver's side, and when Officer Curtis comes up to the passenger side and speaks with the front seat passenger?
Yes, sir.
And could you clearly hear the front seat passenger's voice?
Yes, sir.
Did you recognize his voice?
Yes.
And whose voice was that you heard speaking from the front seat of the front passenger seat of the Toyota Camry in the video?
Dontae Morris's.
All right. And are you, any doubt about that?
No doubt, sir.
All right. Do you see him here in the courtroom?
Yes, sir.
Could you please point him out, identify an article of clothing?
Red sweater.
Your Honor, may the record reflect the witnesses identified the defendant, Dontae Morris?
Yes, sir.
And no further questions, Your Honor.
Any questions, Counsel?
No, sir, the defense would renew previous objections.
So you're released, you're free to go. Thank you very much.
Thank you.
State, you have any other witnesses, please?
Yes, sir. State will call Deputy Estrada.
Stand right here, face the clerk.
Raise your right hand. Do you solemnly swear or affirm the testimony given in this cause be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Right this way.
tell us your full name, please, sir, and spell your first name and your last name?
Yeah, it's Hector Estrada, HectorEstrada.
Thank you. Proceed.
Thank you, Your Honor. Good afternoon, Deputy.
Afternoon.
Where do you work, sir?
At Falconburg Road Jail.
Okay, and do you work for the Hillsborough County Sheriff's Office?
Correct.
And how long have you worked for the Sheriff's Office?
A little over 8 years.
Through your employment at the Hillsborough County Jail, have you had contact with an inmate by the name of Dontae Morris?
Yes.
And was there a period of time where you would see him whenever you were working your shift?
Correct.
How long did that period of time last?
I'd say a little over a year.
Okay. And during that time period, how many days a week did you average that you would work your shifts there at the jail?
I would say 1 week will be 2 days, the following week will be 5.
Okay. So every other week you'd work 5 days, and then every other week from that you'd work 2 days?
Correct.
And when you were working at the Hillsborough County Jail, during that time period, did you, throughout the day, come into contact or come around where Mr. Morris was, where his cell was?
Yes.
Could you, during those time periods when you came into contact or near him, could you hear him speaking to other inmates?
Yes.
And did he ever speak to you?
Yes.
And during that time period, that year, did you become familiar with his voice?
Yes.
It was a yes?
Yes.
Okay. Familiar enough to where you believe you would recognize his voice if you heard it?
Yes.
Have you had an opportunity to view a video copy of the dash cam video from Tampa Police Department Police Officer David Curtis's patrol car that reflected a stop he made of a Toyota Camry, and in which reflects also the murders of Officers Curtis and Kokab?
Yes, I have.
When you viewed that video, were you able to hear the interaction that occurred, the spoken interaction between Officer Curtis and the front seat passenger?
Yes.
Did you hear the portion that occurred when Officer Curtis was on the driver's side of the Toyota Camry?
Yes.
And were you able to hear the interaction that occurred when Officer Curtis approached the passenger side of the vehicle?
Yes.
Did you recognize the voice of the front seat passenger?
Yes.
Who did you recognize that to be?
As the Dontae Morris and the guy that was locked up in Falconburg Road Jail.
Okay. Do you see him here in the courtroom?
Yes.
Could you please point him out, describe an article of clothing?
He's wearing a red sweater with a white collar shirt.
Deputy Stroud, is there any doubt about that in your mind?
No.
Thank you. I have no further questions.
Any questions, counsel?
There are no questions. The defense would renew previous objections and motions.
Sir, you release your subpoena, you're free to go. Thank you.
And in the state, we call Deputy Camara.
Sir, if you would watch your step. Stand right here, face the front.
Raise your right hand. Do you solemnly swear or affirm the testimony given this cause to be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Right this question.
Sir, tell us your full name, spell both first and last names.
Adam Kamara.
Spell both first and last.
A-D-A-M, last name C-A-M-A-R-A.
Thank you. Proceed.
Thank you, Your Honor. Good afternoon, Deputy Camara.
Good afternoon.
How are you employed, sir?
I am a detention deputy with the Hillsborough County Sheriff's Office.
How long have you worked for the Hillsborough County Sheriff's Office?
10 years.
Through your employment with the Sheriff's Office, have you worked in the jail or do you work in the jail?
I work in the jail, yes.
All right. Have you had contact in the past with an inmate by the name of Dontae Morris?
Yes, I have.
And was there a time period in which you had frequent contact with him, if not on every shift that you worked?
Yes.
And how long did that time period last?
Close to 2 years.
During that 2-year period, how many days would you average working a week?
It varies from week to week, but 14 days a month on average.
Okay, so about half the working days of the month.
Yes.
And during that 2-year period, did you come into contact with Mr. Morse where he was held, his cell?
Yes, I did.
Did you hear him speaking with other inmates?
Yes.
And were there occasions when you spoke with him?
Yes.
And during that time period, through your exposure to his voice, did you become familiar with it?
Yes.
Okay, familiar enough to where you would be able to recognize it if you heard it?
Yes.
Have you had occasion to view a copy of a dash cam video taken from Tampa Police Department Police Officer David Curtis's car, which depicts Officer Curtis stopping a Toyota Camry, having conversation with the driver and the front seat passenger, and then attempting to arrest the passenger, and then also depicting Officer Curtis and Officer Kotka being murdered?
Yes.
All right. Were you able to hear the spoken conversation between Officer Curtis and the front seat passenger when Officer Curtis was on the driver's side?
Yes.
Were you able to hear the conversation between Officer Curtis when he approached on the passenger side, when he had conversation with the front seat passenger?
Yes, sir.
Did you recognize the voice of the front seat passenger?
Yes, sir.
And who did you recognize that to be?
Dontae Moore, sir.
Do you see him here in the courtroom today?
Yes, sir.
Could you please point him out and describe an article of clothing?
Wearing a cardigan sweater.
Your Honor, may the record reflect the deputy or the witness has identified the defendant, Dontae Morris?
Yes, sir.
Any doubt about your identification of his voice in the video?
No.
Thank you, Your Honor.
Questions, counsel?
No questions, Your Honor. The defense will review previous motions and objections regarding this.
Sir, you're free to leave your excuse. Thank you very much. Members of the jury, it's been a long day. Let's go ahead and recess. Same admonition, please don't discuss anything with each other about the case. We'll resume tomorrow again at 8. Any problems or concerns with the sequestering situation need to bring to our attention? Okay. And I think tomorrow's lunch may be a better deal for you. Okay. Have a nice evening. We'll see you tomorrow about 8:15.
All right. You got all your notes in your notebooks. Bring it over to the top.
Do you plan on calling these 3 folks that are not on here?
Yes, sir. Yes, sir. Can we approach, Your Honor?
Yes, sir.